Welcome to today's comprehensive edition of the daily UPSC Current Affairs Masterclass analyzing the Hindu editorial for 8th July 2026. This session is a 48-slide analytical breakthrough mapping critical contemporary issues across General Studies Paper I, Paper 2, Paper 3, and Paper 4, providing aspirants with a structured, exam-orientated understanding of the most relevant developments for the 2026-27 examination cycle. The topics we will cover include the civil suit controversy surrounding the Taj Mahal and the Places of Worship Act, the historic Gujarat High Court verdict in the 2008 Ahmedabad blasts case, the evolving paradigm of victim-centric criminal justice in India, challenges facing the Archaeological Survey of India in heritage conservation, modern internal security threats including hybrid terror cells and cryptocurrency financing, the constitutional principles of secularism and constitutional morality, and the ethical dilemmas facing district administrators in maintaining social harmony. Each topic has been selected based on its direct relevance to the UPSC syllabus, its potential to appear in preliminary and mains examinations, and its capacity to develop integrated analytical thinking across multiple papers. Stay focused, take detailed notes, and prepare to gain a decisive edge in your preparation through this systematic analysis of contemporary issues grounded in constitutional principles and ethical reasoning. Segment 1, Heritage, Law and the Taj Mahal Dispute. Taj Mahal Dispute, why in news? A recent civil suit filed in an Agra trial court sought to declare the Taj Mahal a Hindu temple known as Tejo Mahalya and requested the appointment of an advocate commissioner to conduct a survey of the premises. The Allahabad High Court has sought responses from the central government and the Archaeological Survey of India regarding the trial court's rejection of this survey request. The core contention of the petitioners is that 22 locked basement rooms contain Hindu idols and archaeological remnants, and they have demanded access to offer Gangajal and perform religious worship on the premises. This topic tests the boundaries between objective history and revisionist claims, requiring a careful balance between historical preservation, the rule of law, and secular values under general studies mains. For aspirants, this case study provides a unique lens through which to examine the intersection of constitutional law, archaeological evidence, and contemporary identity politics. Understanding the legal and historical dimensions of this dispute is essential for crafting nuanced answers on heritage governance and secular constitutionalism in the Indian context. Historical legacy and ASI evidence. Multiple lines of evidence confirm the established history of the Taj Mahal beyond any reasonable doubt. Shah Jahan built the Taj Mahal between 1631 and 1648 as a tomb for his beloved wife Mumtaz Mahal. Contemporary Persian court chronicles, such as the Padshahnama and administrative records from that period confirm this history with documentary precision. Additionally, European travelers, including Francois Bernier, Jean-Baptiste Tavernier, and Peter Mundei, visited Agra during that period, documenting the construction process, costs, and primary function of the mausoleum in their travelogues. The Archaeological Survey of India has submitted written affidavits stating that there is zero archaeological or structural evidence of a medieval Hindu temple beneath the base platforms. This empirical position based on extensive scientific study represents the authoritative institutional position. For UPSC preparation, aspirants must understand the evidentiary hierarchy that places contemporary records, travelogue accounts, and modern scientific investigation above speculative claims based on pseudo-historical writings. This evidentiary framework is crucial for analyzing heritage disputes. Places of Worship Act and Constitutional Mandates. The Places of Worship Act of 1991 provides the statutory foundation for protecting the religious character of historical monuments in India. Section 3 of this Act bars the conversion of any place of worship of any religious denomination into a different one, establishing a clear legal prohibition against retrospective claims. Section 4 freezes the religious character of all places of worship as they existed on 15 August 1947, creating a definitive cut-off date for legal purposes. The Supreme Court has held that the 1991 Act is an instrument of secularism, protecting the basic structure of the Constitution against divisive, retrospective litigation that could destabilize social harmony. Additionally, Article 49 of the Directive Principles mandates the state to protect monuments of national importance from disfigurement, destruction, or export. Article 51 establishes the absolute fundamental duty of every Indian citizen to value and preserve the rich heritage of our composite culture. Article 25 guarantees the right to freedom of religion, which must not be stretched to claim places of historical, secular heritage as personal properties. Revisionist politics and tourism risks. Sustained legal attempts try to manufacture controversy using pseudo-historical writings, speculative linguistic claims, and revisionist narratives designed to bypass regular civil procedures and circumvent statutory protections. These manufactured controversies pose multiple risks to national interests and social cohesion. The Taj Mahal became a UNESCO World Heritage Site in 1983, representing recognition of its outstanding universal value. Repeated, polarized litigation muddles the international perception of India's cultural stewardship and commitments under international conventions. Furthermore, Agra's economy depends directly on regional tourism, and social disharmony or court-sanctioned excavations threaten livelihoods and business infrastructure around the monument. The cascading impact on local economic activity, employment in the tourism sector, and the international reputation of India as a responsible custodian of world heritage makes this issue significant beyond mere legal technicalities. Way forward: judicial and legal safeguards. Heritage scholars draw a clear distinction between studying historical transformations and altering the religious identity of a recognized national monument. The way forward requires a multi-pronged approach combining judicial vigilance, statutory enforcement, and public education. First, courts must apply judicial vetting by rejecting pleadings at the threshold under Order 7 Rule 11 of the Code of Civil Procedure when they lack sustainable evidence or factual foundation. This threshold filter prevents vexatious litigation from consuming judicial resources. Second, the implementation of the Places of Worship Act 1991 must be strengthened to deter repeat petitions of similar character through swift disposal and exemplary costs. Third, objective public outreach through Insert, ASI, and National Archives should create historical and archaeological awareness programs to counter pseudo-historic narratives circulating on digital platforms, building public immunity against manufactured controversies. Mains Practice and PYQ Framework. For preliminary preparation, aspirants must remember a critical distinction. The Places of Worship Act 1991 freezes the religious character of all places of worship as of 15 August 1947, but the Ram Janmabhoomi case is an exception where the Supreme Court delivered a specific verdict based on legal evidence. Therefore, when answering questions about the Act's general application, candidates should note that while the Act is comprehensive, specific cases may have distinct legal histories requiring careful analysis. For mains preparation, a practice question asks the following: assess the vulnerability of historical monuments to pseudo-historic claims. Discuss the relevance of the Places of Worship Act 1991. The approach should include an introduction defining composite culture and the Taj Mahal legal context, a first body paragraph listing constitutional mandates, including Articles 49 and 51A, a second body paragraph analyzing socio-economic impact of disputes on international reputation and local tourism, and a conclusion focusing on principled distance and constitutional morality as guiding principles for resolution. Segment 2, Internal Security, the Ahmedabad Blasts Case. Ahmedabad Blasts, why in news? The Gujarat High Court has recently upheld the death sentence of 38 members of the banned Indian Mujahideen and confirmed life imprisonment for 11 others in the 2008 serial bomb blasts case, marking a historic judicial conclusion to one of India's most significant terror trials. On 26 July 2008, 21 serial bomb blasts ripped through Ahmedabad within 70 minutes, claiming 56 lives and leaving over 200 injured. The unprecedented target was the Ahmedabad Civil Hospital Trauma Centers, marking the first recorded instance of hospital facilities being specifically targeted during a terror attack in India, demonstrating a new low in terrorist cruelty. The state government was directed to expedite compensation payout before March 2027, addressing the long-pending demands of victims' families. This topic is highly relevant for GS Paper 3 Internal Security and requires understanding of both the legal framework and the ethical dimensions of counter-terrorism operations. Timeline of case and IM evolution. The timeline of the Ahmedabad blasts case illustrates the prolonged nature of terror trials in India and the evolution of the Indian Mujahideen as a terror organization. On 26 July 2008, 21 bomb blasts struck Ahmedabad city, with trauma centers specifically targeted, and the Indian Mujahideen claimed responsibility. Between 2008 and 2009, a massive multi-state investigation captured over 70 suspects, and 35 separate cases were clubbed together for trial. In February 2022, a special court convicted 49 accused, sentencing 38 to death, which is the highest death penalty count in a single case in Indian judicial history. In July 2026, the Gujarat High Court upheld these convictions, confirming the death penalty and ordering state compensation for victims' families. This timeline demonstrates both the determination of Indian investigative agencies and the significant delays that characterize complex terror trials, raising important questions about judicial efficiency and victim rights in the criminal justice system. Internal Security Legal Framework. The primary anti-terror statute applied in the case is the Unlawful Activities Prevention Act, which allows designation of organizations and individuals as terrorists with stringent bail restrictions reflecting the serious nature of such offenses. This statute provides the legal backbone for counter-terrorism operations across India. The 2008 attacks prompted major structural security updates, including the creation of the National Investigation Agency in 2009 to take over federal terror investigations, addressing the need for a specialized federal agency capable of handling complex multi-state terror cases. Prosecution successfully relied on digital trail evidence, electronic communications, and multi-state forensic integration to prove conspiracy under Section 120B of the Indian Penal Code and UAPA provisions. This evidence-based approach demonstrates how modern forensic capabilities have transformed counter-terrorism prosecution, though challenges of digital evidence admissibility and chain of custody remain. Trial deficiencies and delayed justice. The 18-year gap from the crime in 2008 to the final High Court confirmation in 2026 demonstrates systemic judicial delays, violating the fundamental right to a speedy trial guaranteed under Article 21 of the Constitution. This extended timeline raises serious questions about the effectiveness of the criminal justice system in handling complex security cases. Prolonged trials lead to memory fade among witnesses, witness intimidation by accused parties and their networks, and even the death of key witnesses, threatening the integrity of the prosecution case and potentially leading to acquittals or reduced convictions. Dozens of individuals spend over a decade inside high-security custody as under trials, even in cases that eventually lead to acquittals, creating humanitarian concerns about extended pre-trial detention. These systemic deficiencies highlight the tension between thorough judicial process and timely justice delivery, requiring structural reforms in how India handles sensitive security cases. Way forward: systemic CT reforms. Fast-tracking terror cases requires comprehensive technical and infrastructure reforms. First, dedicated, permanent counter-terrorism courts with day-to-day trial mandates must be established to prevent the multi-year delays that currently plague sensitive security cases. Second, specialized witness protection programs need implementation to secure depositions without fear of intimidation that currently undermines prosecution cases. Third, strict statutory timelines for completion of investigation and judicial process under UAPA would create accountability and prevent indefinite delays. Fourth, automated forensic analysis tools should be leveraged to construct rock-solid cyber trails quickly, addressing the digital complexity of modern terror cases. Fifth, hospital security and vital infrastructure security plans need upgrading, creating buffer perimeters around sensitive facilities. Finally, state anti-terrorism squad units must be integrated with NatGrid and multi-agency centers for instant threat assessment and coordinated response across jurisdictions. Mains practice and PYQ framework. For preliminary preparation, aspirants must identify the bodies linked directly with counter-terrorism intelligence sharing. Both the National Intelligence Grid, NatGrid, and the Multi-Agency Center, MAC, are central nodes, while the Narcotics Control Bureau focuses on drug enforcement rather than counter-terrorism intelligence. The correct answer is option A, 1 and 2 only. For mains preparation, a practice question asks the following. Analyzing the 2008 Ahmedabad blasts case, evaluate the balance between absolute national security under UAPA and the fundamental right to a speedy trial under Article 21. The approach should include an introduction outlining the facts of the judgment and security context, a first body paragraph detailing statutory tools of counter-terrorism, including NIA and UAPA, a second body paragraph highlighting challenges of an 18-year trial and effects on justice delivery, and a conclusion suggesting special benches and modernization of judicial apparatus to address systemic delays. Segment 3. Victim-Centric Justice Paradigm. Victim-Centric Justice, News. The Gujarat High Court verdict in the Ahmedabad blasts judgment directed the state government to pay 10 lakh rupees to the families of deceased victims and 5 lakh rupees to the grievously injured before March 2027, representing a significant development in Indian criminal justice. This verdict highlights a jurisprudential paradigm shift from a purely retributive state versus accused focus to a victim-centric restorative paradigm that recognizes the rights and needs of those harmed by crime. This shift is highly relevant for UPSC Mains GS Paper 2, which heavily tests access to justice, structural criminal law reforms, and modern statutory developments in the welfare domain. For aspirants, understanding this transition is essential for crafting comprehensive answers on criminal justice reform, victim rights, and the evolving relationship between state, accused, and victim in the Indian constitutional framework. Criminal justice system in India. The Indian criminal justice system rests on 3 institutional pillars, each with distinct functions and historical orientations. Historically, the Indian adversarial trial model has focused almost exclusively on the rights of the accused, including bail and fair trial protections, and state punitive action, rendering the primary victim a mere prosecution witness with minimal participatory rights in the process. The first pillar is investigation and police, mandated to detect crimes, collect physical and digital evidence, and secure custodial presence under the new Bharatiya Nagarik Suraksha Sanhita. The second pillar is prosecution and courts, responsible for establishing guilt beyond reasonable doubt and ensuring objective application of statutory law. The third pillar is correction and prisons, focused on standard penal correction, reform, and rehabilitation of convicted offenders. This three-pillar structure has historically centered on the state-accused relationship, with victims occupying a peripheral position in the justice process. Legal framework for victim rights. Section 357 of the Code of Criminal Procedure, now incorporated into the Bharatiya Nagrik Suraksha Sanhita, requires every state government, in coordination with the central government, to prepare a comprehensive victim compensation scheme for the rehabilitation of crime victims. This statutory mandate creates a legal obligation for state-level victim support infrastructure. The framework emphasizes restorative justice principles, recognizing that victims have a right to active restoration through financial assistance, psychological support, medical treatment, and long-term societal reintegration assistance. Recent developments under the BNSS allow victims the right to be formally heard and represent their views before a court permits withdrawal of key charges, giving victims meaningful participation in prosecutorial decisions that affect their interests. These statutory developments represent significant progress in victim rights but require effective implementation to deliver tangible benefits. Systemic issues and judicial backlogs. The victim rights framework faces several critical structural challenges that undermine its effectiveness. State victim compensation funds are chronically underfunded, and payouts face massive administrative delays that defeat the purpose of timely rehabilitation support for victims in immediate need of assistance. Hostile courtroom environments and direct interactions with the accused during prolonged trial processes cause secondary victimization, where victims suffer additional trauma from the justice system itself. Furthermore, there are no independent counsel rights for victims during state-prosecuted trials, leaving them without dedicated legal representation to protect their interests. The Justice Malimat Committee of 2003 recommended state-backed victim funds managed via courts. The Justice Verma Committee of 2013 recommended closed-door trials and sensitive policing standards. The Law Commission 268th report advocated statutory victim advocates during trial proceedings. These recommendations provide a roadmap for reform awaiting systematic implementation. Way forward: restorative jurisprudence. The policy focus quote states, "The measure of justice is not merely the severity of punishment for the perpetrator, but the completeness of restoration for the survivor." This principle should guide comprehensive reform of victim rights implementation in India. Global best practice can be drawn from the European Union Directive on Victim Rights of 2012, which establishes mandatory minimum support systems, free counseling, and legal assistance as baseline entitlements rather than discretionary benefits. Institutional victim funds should be created by converting fines levied on convicted criminals directly into a decentralized, swift access victim trust fund rather than routing them through general exchequer pools where they lose their victim-centric character. Digital victim dashboards should introduce single-window digital filing to streamline witness protection applications, compensation processing, and court date notifications. Capacity building through sensitivity training programs across the police and judicial machinery is essential to prevent traumatic line questioning. Mains practice and PYQ framework. For preliminary preparation, aspirants must remember that the Malimat Committee report of 2003 is associated with criminal justice system reforms, not taxation or environmental conservation. This committee made comprehensive recommendations for reforming investigation, prosecution, and victim compensation mechanisms. For mains preparation, a practice question asks the following. Critically evaluate the criminal justice system in India with a special focus on victim rights. Suggest key measures to institutionalize restorative justice. The approach should include an introduction discussing adversarial versus inquisitorial approaches and the BNSS transition, a first body paragraph listing legal statutory frameworks including Section 357A and committee proposals, a second body paragraph highlighting operational issues including funding constraints and courtroom secondary trauma, and a conclusion pitching European model integration and localized victim support networks as pathways forward. Segment 4. Heritage Conservation and ASI Governance. Heritage Conservation, why in news? The Archaeological Survey of India is facing persistent legal and operational challenges stemming from ongoing petitions involving the Taj Mahal, Gyanvapi, and Mathura sites that have subjected core monuments to intense litigation pressure. This situation tests the institutional capacity of ASI to fulfill its conservation mandate while navigating complex legal disputes. The ASI is facing persistent litigation to open structurally fragile chambers, run intrusive surveys, and potentially alter historic definitions of protected monuments. The heritage scholarly line emphasizes a non-negotiable divide between studying architectural transformations versus completely redefining historical monument identities. For aspirants, this topic requires understanding the institutional framework of heritage governance, the legal challenges to monument protection, and the balance between historical inquiry and conservation imperatives that defines ASI's contemporary operating environment. National Archaeological Framework. The Ancient Monuments and Archaeological Sites and Remains Act of 1958 governs the protection of structures of historical and aesthetic value older than 100 years, establishing the primary legal framework for monument protection in India. This act establishes 100-meter prohibited areas and 200-meter regulated areas around national monuments to restrict destructive construction activities that could compromise structural integrity or aesthetic value. The Antiquities Act of 1972 regulates the internal trade and export of historically valuable antiquities and art treasures, checking black market smuggling and protecting movable cultural property. Together, these two statutes form the backbone of India's national archaeological framework, supported by institutional mechanisms including the ASI for monument protection and the Archaeological Survey for excavation and study. Understanding this dual statute framework is essential for analyzing heritage governance questions in the UPSC examination. ASI Governance and Global Standards. The Archaeological Survey of India was founded in 1861 under Alexander Cunningham, giving it a long institutional history of over 160 years of heritage documentation and conservation work. It currently operates as an attached office under the Ministry of Culture, managing over 3,690 protected monuments of national significance and running scientific conservation and chemical treatments to preserve these irreplaceable cultural assets. The ASI provides empirical data for legal challenges through scientific excavations and excavation logs, making it an indispensable institution for evidence-based resolution of heritage disputes. India is a signatory to the 1972 UNESCO World Heritage Convention, which requires strict compliance with the principles of outstanding universal value and physical preservation. Vexatious civil litigation or unauthorized changes inside protected areas risk a site landing on the World Heritage in Danger list, which would have severe consequences for international reputation and tourism. Conservation challenges and obstacles. ASI faces multiple environmental and operational pressures in fulfilling its conservation mandate. Air pollution, acid rain caused by sulfur dioxide emissions forming sulfuric acid, and particulate matter cause irreversible physical staining and marble yellowing, particularly visible on the Taj Mahal's white marble surface, which has required the installation of a pollution control mud pack treatment facility. Urban expansion leads to illegal structural encroachments around heritage boundaries, violating Amshara Act rules and putting pressure on ASI officials who lack adequate enforcement resources. Low budget allocation for heritage upkeep, coupled with a shortage of trained conservators, epigraphists, and stone carvers within the state apparatus, limits the quality and scale of conservation work. These challenges require coordinated responses across environmental regulation, urban planning, and skill development to ensure long-term preservation of India's cultural heritage for future generations. National Preservation Schemes. Several national schemes address heritage conservation through public-private collaboration and infrastructure development. The Adopt a Heritage 2.0 scheme encourages public-private partnerships where corporate entities adopt monuments to build visitor amenities. This model draws inspiration from Italy's corporate sponsorship of Colosseum restoration, demonstrating how private sector resources can supplement government conservation efforts. The Prashad scheme focuses on development of core pilgrimage destinations with high-end, clean infrastructure and aesthetic zoning, drawing from Japanese temple corridors and aesthetic buffer zoning of cultural assets in Kyoto. The National Mission on Monuments develops a central georeferenced database of all historic antiquities and metadata records, similar to the UK's Historic England database, which provides smart, fully public digital heritage mapping accessible to researchers and the public. These schemes represent a multi-pronged approach combining infrastructure development, digital documentation, and private sector participation to strengthen heritage conservation. Mains Practice and PYQ Framework. For preliminary preparation, aspirants must identify correct statements about ASI. It was established in the 19th century by Alexander Cunningham, but it operates as an attached office under the Ministry of Culture, not as an autonomous statutory body under the Ministry of Environment, Forest and Climate Change. The correct answer is option B, 2 only. For mains preparation, a practice question asks the following. Examine the role of the Archaeological Survey of India in the preservation and governance of historical monuments amidst environmental and modern legal challenges. The approach should include an introduction defining ASI's mandate under the Amshara Act 1958, a first body paragraph discussing conservation challenges, including acid rain, legal suits, and tourism pressures, a second body paragraph mentioning central initiatives like Adopt a Heritage 2.0 and PPE models along with global references. And a conclusion suggesting a balanced approach prioritizing academic objectivity over revisionist narratives while strengthening institutional capacity. Segment 5, Internal Security Architecture and Evolving Threats. Internal Security and Terror Verdicts. The Gujarat High Court's landmark judgment confirming death sentences for 38 members of the Indian Mujahideen underscores the state's resolve against terrorism and its commitment to accountability for mass casualty attacks. The ruling highlights the continued danger of domestic radicalization and the role of proxy groups in executing coordinated multi-city operations that overwhelm local security responses. Modern terror outfits have shifted from basic bomb-making to sophisticated operations, leveraging encrypted applications, virtual private networks, and decentralized finances that complicate traditional investigation methods. The security apparatus must adapt from traditional reactive policing to proactive digital and signal intelligence-driven operations that can preempt attacks before they occur. This paradigm shift requires significant investment in technical capabilities, interagency coordination, and human intelligence development to address the evolving threat landscape effectively. Key internal security challenges. Contemporary internal security faces several complex challenges that require multidimensional responses. Terror cells are increasingly decentralized, operating as self-radicalized hybrid entities that remain dormant until triggered, making preemptive intelligence tracing highly challenging and resource-intensive. Terrorist financing misuses virtual assets, cryptocurrencies, Hawala networks, and crowdfunding platforms to transfer resources across state borders undetected by standard banking portals. Coordinated sabotage threats target hospitals, power grids, atomic research zones, transport systems, and digital transaction servers, representing attacks on critical infrastructure that could have cascading societal consequences. These evolving threats require security agencies to develop capabilities in cryptocurrency tracing, critical infrastructure protection, and predictive intelligence that go beyond traditional counterterrorism approaches. National Counter-Terror Architecture. India has developed a comprehensive national counter-terror architecture comprising specialized agencies and coordination mechanisms. The National Investigation Agency is the premier federal agency empowered to investigate and prosecute terror offenses across state borders without needing state consent, addressing the jurisdictional challenges that previously hindered multi-state terror investigations. The Unlawful Activities Prevention Act provides rigorous statutory backing, enabling the central government to ban organizations and designate individuals as terrorists under strict judicial oversight. NatGrid integrates data pipelines from banks, immigration, railways, and telecom systems to provide unified tracking for intelligence agents. The multi-agency center operates under the Intelligence Bureau as a 24/7 node for real-time exchange of threat inputs among federal and state security units. Together, these institutions form an integrated framework for countering terrorism through investigation, prosecution, intelligence sharing, and threat assessment. Technology and security coordination. The primary bottleneck in counterterrorism coordination is the siloed operations of state police units. State intelligence branches must be structurally linked to the federal MAC grid to allow instant, automated data sharing and prevent communication bottlenecks that delay critical threat response. The weaponization of the web presents new challenges. Radicalization via encrypted platforms like Telegram and Signal bypasses traditional telephone interception mechanisms. The use of artificial intelligence, deepfakes, and automated bots to spread communal polarization represents a new frontier of information warfare. Drones are increasingly utilized for cross-border arms drops and surveillance over secure borders, requiring deployment of counter-drone technologies. Addressing these technology-driven threats requires continuous investment in emerging technology capabilities, international cooperation on platform regulation, and development of counter-drone systems for border security. Reforms Anti-Terror Way Forward. Comprehensive anti-terror reforms require multi-stakeholder engagement and institutional development. Community policing should be reinvigorated to re-establish local beat constable systems that build strong communal trust, enabling early identification of radicalization patterns before they expand into operational threats. Dedicated cyber wings must be created as permanent cyber intelligence desks within state police forces to track dark web financing, digital coordinate prints, and coordinate with federal units. FATF compliance and international cooperation must be strengthened under the Financial Action Task Force guidelines to choke cross-border terror funding lines through coordinated financial intelligence and asset freezing mechanisms. These reforms require sustained political commitment, adequate resource allocation, and continuous training to develop the specialized capabilities needed to counter evolving terror threats effectively. Mains Practice and PYQ Framework. For preliminary preparation, aspirants must evaluate statements about NIA. The NIA has the mandate to investigate terror cases across states without seeking prior permission from state governments, and it is governed by a statutory act enacted post the 2008 Mumbai attacks. Both statements are correct, making the answer option C, both 1 and 2. For mains preparation, a practice question asks the following. Terrorism is transitioning from physical coordination to decentralized, digital networks. Analyze the adequacy of India's current counter-terrorism architecture to handle this shift. The approach should include an introduction referencing modern security updates and digital developments, a first body paragraph listing existing frameworks, including NIA, NatGrid, and UAPA, and explaining their limitations against cyber warfare. A second body paragraph highlighting challenges of cryptocurrency tracing and encrypted radicalization, and a conclusion focusing on intelligence collaboration and digital capacity updates needed to address evolving threats. Segment 6. Secularism and Constitutional Morality. Secularism and Harmony News. The Allahabad High Court seeking responses on the Taj Mahal survey request tests the commitment of state institutions to secular constitutional morality. Critics argue that permitting continuous surveys on registered national monuments risks inciting public friction and communal polarization that could destabilize social harmony. Scholars look to the courts to uphold secular principles and deter revisionist litigation designed to bypass established statutory acts like the Places of Worship Act 1991. This topic bridges constitutional law, political philosophy, and contemporary governance, requiring aspirants to understand the distinctive Indian conception of secularism that differs from Western models. The judicial handling of these cases sends important signals about the robustness of secular constitutional values in protecting India's composite culture against attempts at majoritarian revisionism. Constitutional Morality Principles. Dr. B.R. Ambedkar defined constitutional morality not as a natural sentiment but as a cultivated administrative habit. It requires deep commitment to the values of liberty, equality, fraternity, and secularism over majoritarian impulses that might otherwise override minority protections. In landmark rulings like Navtej Singh Johar of 2018 and Sabrimala of 2018, the Supreme Court utilized constitutional morality to strike down discriminatory social norms, prioritizing individual liberty and dignity over majoritarian traditions. Constitutional morality moves beyond literal interpretations of legal statutes to preserve the spirit of constitutional justice. It prioritizes institutional checks and balances, safeguarding minority rights against majoritarian overreach. For aspirants, understanding constitutional morality as a substantive principle rather than mere procedural compliance is essential for tackling complex questions on rights, secularism, and judicial review. Indian secularism and judgments. The S.R. Bommai case of 1994 established that secularism is a part of the basic structure of the Constitution, meaning state power cannot be aligned with any single religious denomination, regardless of political majorities. This judgment provides the constitutional foundation for evaluating government actions through a secular lens. Unlike Western secularism, which mandates a total wall of separation between religion and state, Indian secularism maintains a principled distance, intervening to correct social evils while treating all faiths equally under the Sarv Dharma Sama Bhava principle. Articles 25 to 28 guarantee individual and collective freedom of religion and are explicitly subject to public order, health, morality, and other fundamental rights. This constitutional architecture reflects India's unique approach to managing religious diversity through principled engagement rather than strict separation. Ethical dilemmas in secularism. Administrators and judges face complex ethical dilemmas when secular principles encounter majoritarian pressures. The tension between majoritarian and minority rights manifests when local majoritarian factions pressure authorities to claim or recharacterize historic national monuments, testing the commitment to fraternity and cohesion through guaranteeing equal protection and preserving historical truth without bias. The dilemma of religious freedom versus public order arises when managing localized communal friction sparked by revisionist court petitions and rallies requires balancing Article 25 limits that subject freedom of religion to public order and constitutional morality. The question of judicial activism versus restraint requires deciding when courts should step in to adjudicate complex historical claims without overreaching into legislative or historical inquiry domains, ensuring courts act as legal arbiters rather than commissions of historical inquiry that might exceed their constitutional competence. Secularism and morality, way forward. The core takeaway states, secularism is not merely a political doctrine but a constitutional moral contract that guarantees the peaceful coexistence of our composite society. This principle should guide all administrative and judicial actions in sensitive communal matters. To uphold this commitment, statutory safeguards must be strictly enforced, particularly the Places of Worship Act 1991, to deter repeat petitions of similar character and protect social cohesion. Constitutional values and ethical education should be integrated in schools to counter divisive social media campaigns. Administrative and police forces must maintain absolute neutrality during localized communal disputes, upholding the rule of law without bias. Interfaith platforms and local peace committees should be leveraged to address grievances and resolve friction amicably before they escalate into larger conflicts requiring judicial or executive intervention. Mains practice and PYQ framework. For preliminary preparation, aspirants must remember that secularism was formally added to the preamble of the Indian Constitution through the 42nd Amendment Act of 1976, not the 24th, 44th, or 86th Amendments. The correct answer is option B, the 42nd Amendment Act 1976. For mains preparation, a practice question asks, what do you understand by the term constitutional morality? Evaluate its relevance in resolving sensitive communal and historical disputes in India. The approach should include an introduction defining constitutional morality, citing Ambedkar and recent Supreme Court rulings, a first body paragraph contrasting literal legality with the spirit of justice, including the rule of law and secularism, a second body paragraph analyzing its application in sensitive disputes like the Gyanvapi and Taj Mahal legal issues, and a conclusion emphasizing the importance of institutional neutrality and protecting secular harmony. If you are finding this analysis valuable, subscribe to the channel for more such structured current affairs breakdowns. Segment 7, Judicial Disputes and Historical Arbitration. Judicial Disputes, why in news? The Allahabad High Court seeking responses on the Taj Mahal temple civil suit highlights the growing trend of legal courts handling sensitive historical disputes that were traditionally left to historians and archaeologists. This trend raises questions about the appropriate role of the judiciary in adjudicating historical claims. Critics argue that permitting continuous surveys on registered national monuments risks inciting public friction and communal polarization, potentially converting legal proceedings into instruments of social conflict. The judicial dilemma involves deciding when to reject frivolous claims at the threshold versus when to permit objective, scientific surveys to ascertain historical facts. This balancing act requires careful consideration of both the evidentiary record and the broader social consequences of judicial interventions in contested historical narratives. Constitutional role of judiciary. The judiciary serves as the constitutional custodian, ensuring individual and collective fundamental rights under Articles 14, 19, 21, and 25 are protected against state or majoritarian overreach. This guardian function is central to constitutional democracy and requires independence, impartiality, and wisdom in its exercise. The judiciary is also responsible for resolving delicate civil and property disputes through objective, evidence-based application of codified laws, independent of public sentiment that might otherwise influence outcomes. However, constitutional separation of powers requires courts to avoid performing legislative duties or acting as perpetual historical inquiry panels that exceed their institutional competence. Understanding these limits is essential for appreciating the appropriate scope of judicial intervention in historical disputes. Landmark religious dispute cases. The Ayodhya verdict of 2019 held that land disputes must be adjudicated based on legal property claims and archaeological evidence rather than mere religious faith, establishing a clear evidentiary standard for such cases. The verdict also underlined that the court cannot rewrite history or correct past historical wrongs, focusing strictly on resolving present legal title actions. The ongoing Gyanvapi and Mathura disputes test the boundaries of the Places of Worship Act 1991. Courts are balancing requests for scientific surveys by the ASI with the statutory bar on altering religious character. These cases highlight the risk of opening finished historical debates and creating public friction through judicial proceedings that may be intended as objective inquiry but produce social tensions as side effects. For aspirants, understanding the judicial reasoning in these landmark cases is essential for analyzing the intersection of law, history, and religion in the Indian constitutional framework. Challenges in judicial review. The judiciary faces multiple operational challenges in handling vexatious historical claims. The filing of frivolous lawsuits to bypass regular civil procedures and incite public debate requires effective threshold mechanisms. Order 7 Rule 11 of the Code of Civil Procedure provides the legal tool for courts to reject pleadings that disclose no sustainable cause of action at the initial stage. ASI surveys risk causing physical damage to fragile, ancient archaeological structures, requiring restrained approaches, restricting surveys to non-invasive methods like ground-penetrating radar that can investigate subsurface features without causing structural harm. Diverting limited judicial time and resources toward complex, historic, and religious disputes contributes to systemic court backlogs, requiring strict time limits for resolving title suits efficiently. These challenges demand institutional reforms that balance thorough adjudication with timely disposal of cases. Reforms Judicial Restraint Policy. The Supreme Court has repeatedly emphasized that courts of law should not act as historical inquiry boards to correct past wrongs, establishing an important principle of judicial restraint in historical matters. This guidance should inform lower court approaches to sensitive heritage disputes. Reforms should include rejecting vexatious litigations by applying high costs and penalties for filing speculative historical lawsuits lacking primary documentary proof. Lower courts must respect statutory limits like the Places of Worship Act 1991 during initial hearings of civil suits, preventing protracted litigation that circumvents protective legislation. A high evidentiary threshold must be maintained, relying strictly on verified historical texts and non-invasive archaeological data over oral traditions that may be subject to revisionist interpretation. These reforms would help preserve judicial resources for genuine disputes while deterring motivated litigation. Mains Practice and PYQ Framework. For preliminary preparation, aspirants must remember that under the Code of Civil Procedure, a court can reject a plaint at the initial threshold under Order 7 Rule 11, not under Order 6 Rule 17, Order 8 Rule 1, or Order 9 Rule 13. The correct answer is option B, Order 7 Rule 11. For mains preparation, a practice question asks the following: the judiciary is increasingly called upon to resolve disputes of a historical and religious nature. Analyze the challenges and suggest key judicial guidelines to handle this shift. The approach should include an introduction defining the role of the judiciary as an arbiter of legal rights and reference sensitive monument disputes, a first body paragraph discussing judicial review limits and CPC Order 7 Rule 11 thresholds, a second body paragraph highlighting challenges of balancing public sentiment with scientific evidence, and a conclusion suggesting a model of judicial restraint and strict adherence to statutory acts as the appropriate framework. Segment 8, Public Administration Ethics in Security Management. Public Administration Ethics, News. The conclusion of the 18-year-old Ahmedabad blasts case and the delivery of state victim compensation highlight critical ethical dilemmas in security management that require careful navigation by district administrators and police leadership. This case provides important lessons for ethical governance in sensitive security contexts. District administrators and police forces must balance hard national security protocols with empathy and victim protection, ensuring that security operations do not become dehumanizing exercises that compound the trauma of victims. Delivering swift, impartial compensation is a core ethical responsibility under the Public Service Values Charter, requiring administrative efficiency alongside procedural fairness. This topic is highly relevant for GS Paper 4 and requires aspirants to understand how ethical principles translate into practical administrative decisions in crisis situations. Ethical counter-terror principles. Counter-terrorism operations must be guided by fundamental ethical principles that protect human dignity and constitutional values. The principle of proportionality requires that state security responses be proportional to the threat level, ensuring that stringent counterterrorism measures do not violate fundamental human rights or civil liberties beyond what is strictly necessary. Protecting human dignity requires maintaining basic ethical standards even during high-intensity counter-terror operations, interrogation procedures, and preventive detentions, where the temptation to override individual rights may be strongest. Absolute impartiality demands that intelligence profiling, police deployments, and state surveillance operations remain completely free of communal, regional, or political bias. These principles form the ethical foundation that distinguishes democratic counterterrorism from authoritarian approaches that sacrifice liberty for security. Public service and ethical values. The Nolan Committee principles provide a foundational framework for public service ethics. Integrity requires placing public safety and national security above all personal, financial, or political gains. Objectivity demands relying strictly on verified intelligence reports and empirical evidence during critical security briefings rather than speculation or political preferences. Accountability means taking ownership of security decisions, including operational mistakes and collateral damage, through transparent review processes. Beyond these principles, delivering empathic justice requires upholding the rights of victims through swift, time-bound delivery of compensation and medical rehabilitation packages. Securing safe, non-discriminatory access to legal aid and protection for marginalized communities during security crackdowns maintains constitutional values. Maintaining open, transparent communication channels helps check rumors and maintain communal calm during sensitive operations. Ethical dilemmas in security. Security administrators face complex ethical dilemmas that require careful moral reasoning. The liberty versus security dilemma requires balancing the safety of citizens with the civil liberties and privacy rights of individuals, with the test of proportionality requiring that any infringements have a clear statutory basis and serve a legitimate security aim. The harsh punishment versus reform dilemma involves deciding whether to support capital punishment for terrorist acts versus focusing on rehabilitating offenders, requiring restorative justice principles that balance punitive measures with structural victim compensation. The confidentiality versus transparency dilemma requires withholding intelligence files from the public versus maintaining transparent accountability during trial processes, requiring judicial oversight to ensure sensitive files are scrutinized in camera under strict court monitoring. These dilemmas require administrators to apply ethical frameworks while navigating operational pressures. Way forward, public service ethics. The core principle states ethics over expediency. Security policies should prioritize constitutional values and ethical administration over short-term political or tactical advantages that might compromise long-term institutional integrity and public trust. A mandatory code of ethics should be developed for security agencies, emphasizing human rights and proportionality during operations and providing clear guidance for decision-making in complex situations. Emotional intelligence should be integrated into police training to manage community disputes calmly and check polarization that can escalate into larger conflicts. Independent oversight bodies should be established to investigate allegations of administrative bias or excess, ensuring accountability mechanisms that maintain public confidence in security institutions while protecting operational effectiveness. GS4 Case Study and Keywords. The case study scenario presents a challenging ethical situation. You are the district magistrate of a historical city. A local group has filed a court petition claiming that a major secular heritage monument is actually an ancient temple, demanding access to offer prayers. Tensions are rising, and a protest march is planned. Explain your course of action as aim to maintain order and constitutional morality. Key ethical interventions include keywords like constitutional morality, principled distance, Nolan principles, impartiality, and emotional intelligence. Action 1 involves convening peace committees with interfaith leaders to diffuse local rumors and establish direct communication channels. Action 2 requires ensuring strict administrative neutrality, deploying police forces symmetrically without communal bias. Action 3 involves presenting empirical reports by the ASI to the court, checking speculative litigation with documentary evidence. Action 4 requires securing the heritage boundary zone, restricting unauthorized assemblies to protect public order while respecting legitimate expression of grievances through legal channels. Thank you for engaging with this comprehensive analysis of 8th July 2026 UPSC Current Affairs, covering heritage conservation, internal security, criminal justice reform, secularism, and public administration ethics. Your dedication to mastering these complex intersections of law, policy, and ethics is what drives quality learning and examination success. This edition has equipped you with structured knowledge on the Taj Mahal civil suit and the Places of Worship Act, the Ahmedabad blasts verdict and counter-terrorism architecture, victim-centric justice and BNSS reforms, ASI governance and heritage conservation challenges, evolving terror threats and security coordination, constitutional morality and secular principles, and judicial review in historical disputes. Each topic provides exam-orientated frameworks for preliminary factual questions and main analytical answers across GS papers I, 2, 3, and 4. Subscribe and turn on notifications to stay updated with daily editorial analysis, model answers, and structured current affairs breakdowns designed for serious UPSC aspirants. Access revision modules and join our growing learning community committed to excellence in civil services preparation. Together, we turn complex contemporary issues into structured knowledge, helping you approach the examination with clarity, confidence, and comprehensive preparation that maximizes your scorecard potential. Empower your journey toward success.